The Supreme Court decided a big case in the copyright world in 2021 in Google versus Oracle. In this presentation, I'll provide an overview of copyright law, including what is generally protectable through copyrights, the exclusive rights granted through copyrights, and the defense of fair use. Then I'll go over what happened in Google versus Oracle, address several cases that have been or may be implicated following Google versus Oracle, and then talk about a few issues that remain to be resolved after Google versus Oracle. So what is a copyright? A copyright is a type of intellectual property that protects original works of authorship as soon as an author fixes the work in a tangible form of expression. Works are original when they are independently created by a human author and have a minimal degree of creativity. A work is fixed when it is captured, either by or under the authority of an author, in a sufficiently permanent medium such that the work that can be perceived, reproduced, or communicated for more than a short time. For example, a work is fixed when you write it down or you record it. Various items can be protected through copyrights. What you see on this slide are the general categories for copyright protection that the U.S. Copyright Office provides for when a work is to be registered. As you will see, and as will be important in discussing Google versus Oracle, literary works can include computer programs and source code under certain circumstances. The Copyright Office defines a computer program as a set of statements or instructions to be used directly or indirectly in a computer to bring about a certain result. Copyright protection for a computer program extends to all of the copyrightable expression embodied in the computer program. The copyright law does not protect the functional aspects of a computer program, such as the program's algorithms, formatting, functions, logic, or system design. As I mentioned, one of the categories that you can seek registration in at the Copyright Office is literary works, but we also have categories including musical works, which can include any of the accompanying words, dramatic works, including any accompanying music, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures and other audiovisual works, sound recordings, which are works that result from the fixation of a series of musical, spoken, or other sounds, as well as architectural works. This next slide identifies some of the items that are not protected through copyright, and these are things that are identified by the U.S. Copyright Office. These include ideas, procedures, methods, systems, processes, concepts, principles, or discoveries, works that are not fixed in a tangible form, such as a choreographic work that has not been notated or recorded, or an improvisational speech that has not yet been written down, titles, names, short phrases and slogans, familiar symbols or designs, mere variations of typographic ornamentation, lettering or coloring, and mere listings of ingredients or contents. So the copyright law provides a copyright holder certain exclusive rights depending on the type of copyright involved. These exclusive rights include the right to reproduce the work in copies or phonorecords, the right to prepare derivative works based upon the work, the right to distribute copies or phonorecords of the work to the public by sale or other transfer of ownership, or by rental, lease, or lending. You can also have the right to perform the work publicly if it's a literary, musical, dramatic, or choreographic work, a pantomime, or a motion picture or other audiovisual work. You have the right to display the work publicly if it's a literary, musical, dramatic, or choreographic work, a pantomime, or a pictorial, graphic, or sculptural work. This right also applies to the individual images of a motion picture or other audiovisual work. And then you also have the right to perform the work publicly by means of a digital audio transmission if the work is a sound recording. So let's look at, there's also some defenses to these exclusive rights. So if someone sues you for copyright infringement, there are certain defenses that are provided by the copyright law. Specifically, 17 U.S.C. Section 107 sets forth the law of the defense of fair use. Fair use is considered to be a limitation on the exclusive rights associated with a copyright. The fair use of a copyrighted work, including that use by reproduction in copies or phonorecords or by any other means specified, for purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research, is not an infringement of copyright. In determining whether the use made of a work in any particular case is a fair use, the law gives various factors to be considered, including the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the potential market for or value of the copyrighted work.